My name is Jacob Blizzard, and I'm a board-certified criminal law and criminal appellate specialist attorney, and I want to talk to you guys today about the 2255 writ application or motion for relief from a conviction in federal court. So you've been convicted. The 2255 motion or writ is that thing that you seek to overturn your conviction or sentence with it. So today I want to talk to you specifically about what happens after you file the 2255 writ application. The first thing that happens is the court is going to examine it, often through law clerks or maybe even a magistrate judge if it's assigned to a magistrate judge, but the court is going to examine it to determine if it is frivolous, meaning that on its face you cannot succeed, or it's so against the record of proceedings that the allegations are just unbelievable to be considered frivolous. So your application or your motion could be denied without anything further if the court determines on its face there's nothing to it. That's hurdle number one. So you want to get over hurdle number one, and that's by sticking to the grounds that work. And we talked about that in another video about what grounds to use in a 2255 motion. So the next thing that happens is the court then, if it's not found to be frivolous, will order the government to respond. Usually courts give between 30 and 60 days for the government to respond to the allegations that you've brought in your motion or application. The government files a lengthy response that addresses the merits of the grounds that you've brought forward, and you then, often the court has a schedule within its order ordering the government to respond that allows a reply timeline. So that means, within 20 days of the government's response or some other timeline that the court sets, then you would be entitled to file a reply to the government's response. Notably, you shouldn't file a reply that just reiterates what you said before. You want your reply to really go to the heart of what the government has said in their response to you. And you just want to discredit whatever they have to say about your motion. So then going on from there, the court will then decide whether or not there are contested issues and whether or not it needs to take in evidence of some kind. The court can take in evidence a number of ways. It can take it in through affidavits. It can take it in through a live hearing, and that hearing could be assigned to a magistrate judge or it could be heard by the district judge. And so the court would receive the evidence if it determined that there was evidence that needed to be received, and then the court would ultimately make a decision in the case. Unlike in some state habeas petitions, the federal writ is something decided by the district judge in the case. They decide whether you're entitled to relief or not. And they are, in a sense, the final say, but you can appeal in some circumstances. But they are the ones who are going to decide. So often you could be in front of the same judge that you pled guilty in front of or you were in trial in front of. And I know that can give you an uneasy feeling. But that's just this system that we're part of, because 2255 motions have to be brought in front of the court where you were convicted. Keeping that in mind, try not to make allegations that are outlandish, that the judge is going to know or suspect are false or conspiratorial, that go far beyond what he believes could be possible, because this judge sat on your trial or sat on your plea, and so he's going to have some idea, especially in the trial context, of what your case was about. You also want to make sure in your motion that you're alleging facts outside of the record. You're wanting to talk about things that happen, not just as if it's an appeal saying that there are bad things that happened in my trial, but you want to talk about ineffective assistance of counsel, prosecutorial misconduct, Brady violations, the lack of jurisdiction of the court, things of this nature. That's how you are successful in 2255, and that's how you get past that initial hurdle where the judge is going to say, is this claim frivolous? If you're just making claims based on the record, those can be considered frivolous claims. And we'll discuss the best types of claims and how to put those forward in another video, but something to keep in mind when you're thinking about the process of what happens once you file the 2255 motion. Thanks guys for watching. We'll see you next time.